Hello students, welcome back to Mentor's Law Entrance Coaching Center. As part of our CLAT Nation program, we have already done Law of Contract Class 1 and today will be Law of Contract Class 2. So those students who have missed the previous class, please click on the I button and get to the previous class. Watch that classes and get back here as soon as possible. So we will be discussing some new principles in today's session. So let's get to today's session. And my name is Advocate Harrison Fassel. In previous session, I have discussed many major topics. Today we'll be starting our session with void and voidable contracts. We'll be looking into the details of void and voidable contracts. Then we'll be looking into our exercise. Then we will move on to other principles. Okay, this is how we have been doing for your previous classes. I believe it has been very useful for you. And I have already mentioned if there is any problem with my classes or if I have to improve in any way, please feel free to comment on comment section. I'll keep that in mind and I'll improve on it. So let's move on to void agreements and voidable agreements. So look at voidable agreements. Okay, we have in our previous class itself we have discussed about voidable agreements, and I have given you a simple tip to remember what are voidable agreements. The simplest tip is an agreement where the consent is not free. That contract will be, or that agreement will be, a voidable agreement. Okay, you can you call it an agreement, you can call it a contract, whatever. Okay, it will be a voidable one. Okay, it will remain as a contract as long as the person whose consent is so obtained wants to remain in that contract. When he wants to make it a void, the contract will become void. That is the specialty of voidable contracts. It will depend upon the aggrieved party. Okay, so consent must be free. Okay, so what are the situations in which the consents are not given freely? That are the things that you need to understand. Under all those circumstances, the contract will become voidable. So you need to study only 4 headings. Everyone tells you there are 5 situations in which the consent given is not free, but you don't have to study the 5 circumstances. You only need to understand 4 circumstances, because the 5th one everyone I'll get to that later. So things are coercion, okay, undue influence, misrepresentation and fraud. Under these 4 headings, under these 4 circumstances, the contract will become voidable. Okay, the contract will become voidable. So that is a list that we are going to look into here. And the 5th one is mistake. Okay, but in situations of mistake, the contract will not become voidable. Under mistake, the contract at under mistake it's a very broad area. You don't have to study that the whole broad area. Under mistake, 95% of the time the contract will become void. Okay, it will not become voidable, it becomes void. So you need to study only 4 headings. Okay, learn these 4 headings. We'll look into each of that headings right here. First of all, coercion. Coercion means, what is coercion? Coercion means putting someone under fear, and like simple English meaning, putting someone under the fear or under threatening. We are threatening someone to get into a contract. That is the meaning of coercion. Simple meaning of coercion. We are threatening someone to enter into a contract. Okay, what is that threatening? That we will commit an act forbidden under Indian Penal Code. This was old law. Indian Contract Act is a pre-constitutional law. Okay, so BNS is only introduced in 2023. So now we can say BNS, but in the Indian Contract Act, it expressly says what? IPC. Okay, committing an act forbidden by IPC, or threatening to commit an act forbidden by IPC, or unlawfully detaining or threatening to detain any property with the intention of causing or enter into an agreement. Okay, so we are threatening someone or we are detaining something that belongs to that person in order to coerce that person into a contract. Okay, I'm saying that I will kill him. I will kill his son if he does not enter into a contract. So this is coercion. Okay, we are threatening that person to enter into a contract. Next one is undue influence. What is undue influence? Undue influence are circumstances in which a person is in a position to dominate the will of another. Okay, one person is in a position to dominate the will of the other. How can we dominate? How can we have a position to dominate the will of another person? That is perfectly explained here, where he holds a real or apparent authority, where he stands in a fiduciary relation, where he makes a contract with the person when he okay, I'll explain this later. Don't panic. Where he makes a contract with the person when the mental capacity is temporarily or permanently affected by reason of age, illness, mental or bodily distress. So what are these circumstances? Real and apparent authority. Sometimes the person with whom I am entering into contract maybe in a higher position, he is my boss. Okay, so if I do not enter with him into a contract, there is a good chance that I will become jobless. So since such a situation is there, I have entered a contract with him. Okay, so that there is a real authority there. Okay, then fiduciary relationship. What do you mean by fiduciary relationship? Okay, fiduciary relationships are relationships based on trust. Okay, like advocate-client relationship, doctor-patient relationship, and the abuse of fiduciary relationship, that is undue influence in fiduciary relationship, is more commonly seen in in the Swami Guruji idols and their followers cases. There are many instances in which there will be idols, that is Guruji, Swamijis, Ustads, where they will have their own trust and they will ask their idols, they will ask their followers to give up all their property. Okay, they'll ask them to transfer all their property in the name of trust and come live with them. Okay, so what happens here is their legal heirs will come to us and they will ask us, and they will tell us that they need to get that property back. So how to get that property back? We will make a claim on undue influence. They were in an fiduciary relationship, or they had an apparent authority over them. Okay, they had an apparent authority over them. So what they did, they using undue influence, transferred this property in their name. So we can use these laws for many purposes. And also about the last point. Okay, we have read this last point. Made a contract with a person when the mental capacity is temporarily or permanently affected by reason of age, illness and mental or bodily distress. Which means, think about a scenario. Okay, this usually happens. This always happens in every now and then. That is, think about a circumstance when a father is residing with one of his son who is in his native place, and his other heirs are abroad. And there is a very good chance that this father might have transferred all his wealth or estate to the son with whom he is residing. Okay. So what happens is, after the death of this father, okay, the other heirs might make a claim towards what this father might have transferred to this son. It is mainly done under undue influence, because apparently the father is was in a very vulnerable position, because he is very old and he is the only son here in the native place to take care of him. So that is a vulnerability. And again, here the son who is residing with him has an apparent authority, right? He is the only one capable of taking care of him. So he had an apparent authority, and other person is vulnerable. So that is also a perfect example of undue influence. Okay, it is a potential case. There is a potential case for undue influence. These are real life circumstances that may arise in your legal career if you are into litigation. So these are two things, okay, coercion and undue influence. Coercion is threatening someone and making him entering into a contract. Undue influence is the abuse of position, okay, apparent or real position to dominate the will of the other person. So these are the two things to keep in mind. Then going forward, we are looking into fraud and misrepresentation. This might seem similar. Fraud and misrepresentation seem similar to many persons, but these are very different, and it is easy to understand how different these things are. Misrepresentation is not fraud. Fraud is not misrepresentation. Okay, let's discuss about fraud. What is a fraud? In both these cases, the contract will become voidable, but you have to differentiate between fraud and misrepresentation, because one has fraud will result in severe penalty. So we have to know the difference between fraud and misrepresentation. Fraud means, look here, representation or assertion, and it must be false. We are making a representation. We are telling something to someone to enter upon a contract, and what we are telling them is a lie. It's a false. It is a untrue statement. Untrue statement. It's a false statement. Suggestion as a fact which is not true, which he doesn't believe to be true. When I am saying that to the other person, when I am making a statement or suggestion, I myself know that what I am saying is not true. Then active concealment of fact, one having the knowledge or belief of facts. Okay, I know certain things and I am concealing about, active concealment. When they are asking about it, I am not saying about it. That is the active concealment. They are asking me and I am not telling them anything. I am telling about different other things. Okay, that is active concealment. So active concealment also amount to fraud. For example, just think about it. Someone is coming to buy my car. Okay, I'm telling them this is a perfectly fine car, its engine works fine, but the engine doesn't work fine. Okay, engine has several issues. Okay, it has been rusted or some other issue. The engine has issues, but I am telling this engine is perfect. It never had any issue so far. It is a perfect lie. And they have been asking me, but does this vehicle have any problem with radiator? And my radiator has been blown. Okay, it is not working at all. And I am telling this vehicle tire is very new. Okay, I have serviced this vehicle 2 weeks before. I'm not answering their questions. I'm telling some other things. Okay, this is active concealment. Doing so will also result in fraud. Okay, a promise made without the intention of performing it. Any other act fitted to deceive. Okay, or I am saying that you enter upon the contract, I will repair this within 1 week. But my intention, I do not intend to repair it. Or that's not actually correct. The actual thing is, I'm telling them I will supply them first class export quality rice. And I have no intention of supplying first class rice because I don't have it. I only produce second class, third class grade rice or fruits. I only produce a non-export quality fruits or grains or anything. So that by inducing someone, I am stating lies to induce someone to enter upon a contract. This is called a fraud. Simple as that. You will understand that. Okay, any such omission are specifically declared to be fraudulent. Mere silence as to the fact is not fraud unless it is a duty to speak. Like I have said before, like active concealment, actively not speaking about something. Active, when they are asking, I am not replying to that. That is active concealment. That will become fraud. But they didn't ask me anything, and so I didn't tell them about anything. It does not amount to fraud. Okay, they didn't ask how is the radiator. I didn't talk about how is the radiator. So that's fine. Okay, once they have asked me and I am not talking about it, I am not telling them anything about it, it will become active concealment. That's what we are discussing right there. There is a concept called uber me fide. Okay, uber me fide. Or uber me fide, you can call it whatever you want. This means contracts of utmost good faith. In certain kinds of contract, we have to disclose everything. For example, insurance. We have to disclose everything. Okay? We have to disclose everything. These are contract made out of utmost good faith. Okay? Under such circumstances, silence would amount to fraud. Okay? So, uberime fide means contract of utmost good faith. Okay, just for your knowledge, simply for your knowledge. Keep that in mind. So these are the things that make a circumstance a fraud. Okay, so what is misrepresentation? Okay, let's look at it. There must be a representation of fact. There is I have said something about my product or vehicle or something that I am about to sell, or upon which I am trying to make a contract. It must be made before the conclusion of the contract. Okay, I have made that representation before the conclusion of the contract. It should be made with view to induce the other party to enter into a contract. I said that because I want them to enter upon the contract. Okay, I want them to, just like fraud, I am telling this is a A-grade rice. This is an export quality item. I am telling that so that to induce them into the contract. It must have induced the other party and must have entered into the contract. They should have believed it and they should have entered upon the contract. The representation should be false one and the person made it honestly believed it to be true. This is the one thing that separates misrepresentation from fraud. Everything else is same with that of a fraud. Everything is like fraud. The one thing that separates misrepresentation from fraud is the idea that a fraud already knows he's lying. But a person making representation believes that what he is saying is true. Okay, he believes what he is saying is true, but it's actually false. Okay, he didn't know that. So that is the difference between fraud and a misrepresentation. Okay, should be false one and the person made it honestly believed it to be true. He thought he had a first class rice. Okay, he had first class rice. Maybe he had the export quality rice with him and he put it inside a warehouse, and where there was rain or leakage or something, and by that leakage his rice got spoiled. Okay, so what happened then? They are made into a contract and then he has delivered this product without checking them. So at the end, the other party, when he took the delivery, when he took look at the rice, these were not export quality rices. So he would normally sue for fraud. So the other person will claim that this is not fraud. Please sir, this is not fraud. This was a misrepresentation. There is no need for severe penalty. This was a misrepresentation. When the first person collected these things, it was of export quality. But other things which happened, which he couldn't foresee and he didn't check. So that was a misunderstanding that was going on. That is why this happened. So we will be claiming for misrepresentation. So this is what happens during a case. Okay, one person will file for fraud, the other person will say no, it was not fraud, it was a misrepresentation, because to reduce the penalty. Okay, whatever. These are different circumstances. Okay, so fraud means actively we are a fraud. Actively we are concealing something. Actively we are lying. But in misrepresentation, we are not lying. We believe we are saying true. But what happens is the thing we thought true was false. That is the basic difference between fraud and misrepresentation. So now what happens is we will be looking at void agreements. Now we know what are voidable agreements. 4 situations. Remember these 4 situations: coercion, undue influence, fraud, misrepresentation. These 4 headings, under these 4 circumstances, a contract is voidable. Okay, if the person who has been fraud, I am the person who has been frauded. He has cheated me, dishonestly made me enter into a contract. But if I am not filing a case, if I am not interested in filing a case against him, or I am not going against him, this will remain as a valid contract. Somebody coerced me into a contract, and if I am remaining in that contract willfully, then that will be a valid contract. Okay, as long as I need it. Okay, that is the specialty of voidable contracts. Now, void agreements means it doesn't matter what you want. Even if both of you parties, okay, want to make this contract valid or this agreement valid, So or if you want to make this agreement into a contract, this will not be available. This will never be a contract. That is the void agreements. This is void in no circumstance. Even when you both the parties want it to work, it won't work, because law says it won't work. It is void, it is null, it's zero. What are the circumstances? An agreement of which consideration or the object is not lawful. I have discussed it in my first session itself. When the consideration is not valid, what happened? When the consideration is not legal, the contract will become void. If I am contracting for buying drugs, if the contract between two persons is for buying and selling of drugs, that is that is an illegal agreement. The consideration is illegal. So what happens? The contract is void. You cannot enforce it. Okay, that's what happens. So that's one thing. Next, agreement without consideration. An agreement without consideration is void. There are exceptions to this that we will study separately. Okay, there are exceptions to the rule of agreement without consideration. We will discuss that later. Okay, but as a general understanding, agreement without consideration is void. Now remember this: whenever there is a contract or there is an agreement without consideration, it is a void one. Okay, so what is an example of an agreement without consideration? I'm telling someone, okay, or A tells to B that he will sell his bike to B for free. Okay, I'm telling someone that I will sell my bike free of course. You come to my home tomorrow, I'll give you my bike. So he came to my home the very next day, and he asked me, can you give me the key to the bike? And I will tell him that no, I will not give you my bike. And he will be frustrated. So, and he will ask me, hey, you gave me an offer, I have accepted it, now this is a valid contract. Then I will say, but there is no consideration. I didn't agree to any amount. I thought about giving it gratuitously. I am thinking to give it to you gratuitously, free of cost. Then I thought, no, why should I give it to you gratuitously? No, I am not selling this gratuitously. So we cannot make a claim upon something that a person has offered to us freely, gratuitously, okay, without cost. So in such circumstances, we cannot make any claims relating to it, because our agreement which says I will give something to you free of cost is not enforceable by law. It is a gratuitous act. He can give it or he cannot give it. It's the option of the person who is making that offer. That's the problem with the agreement without consideration. Okay, got my point? So an agreement without consideration is void. Keep that in mind. An agreement in restraint of marriage, okay, an agreement restraining a person from marrying is a void agreement. Okay, telling someone that you can't marry my daughter, I will give you 10 lakhs if you don't marry my daughter. We can buy that, we can take that money from that person and still marry his daughter. Okay, because it is a valid, because the contract with him, the father, is what? It is a void contract. It is not an enforceable one. So agreement in restraint of marriage is a void agreement. Okay, agreement in restraint of trade, telling someone you cannot do certain business, entering into a contract saying you cannot do certain business, is all, you cannot do a certain profession, you cannot practice a certain profession. It is also a void contract, void agreement. It's void basically. And actually in real life practice, there is this Competition Act, Trade Secrets Act, and different other act that has provision relating to preventing certain persons or group of persons or companies from engaging in certain business. But that's not for you. Under general principles of contract, we cannot restrain a person from practicing any trade or business. Now, agreement in restraining of legal proceedings. Okay, we are including a certain clause or making some person to sign an agreement which says that you will never initiate a legal proceeding against us. You will not file a case against us. That is not a valid contract. It is a void agreement. It is always a void. You cannot tell someone, you cannot make a contract. Okay, you cannot make an agreement upon which you are saying you will never file case against us. That's not possible. That's under Indian Contract Act. Okay, an agreement restraint of legal proceeding. Agreement which is ambiguous and uncertain. And we have learned about this in the offer itself, right? You cannot you cannot make a contract in ambiguous term, which that contract is not stating at what amount you are buying, or a contract which is not stating what are you selling. Okay, the contract should be certain and definite. You should have what is the offered price, what is the buying price, okay, what is the thing that is sold. Everything should be proper in a contract. Okay, it cannot be ambiguous and uncertain. And finally, wagering agreements. Wagering agreements basically means, we will discuss that later, wager and contingent contract. But for your idea, wagering contract simply means betting. Betting is a void contract. Okay, betting is a void agreement. It cannot be enforced by court. No claim relating to betting will be enforced through court. That is what general principles of contract says. But in real life there is lotteries. Some states, in Kerala there are lotteries. In Goa there is casino. So how do they operate? They are not operating under Indian Contract Act. They are operating in Kerala, the Kerala Lotteries Act. There are Casinos Act. So legislation, separate legislation can be made on several things. Even in Indian Contract Act, in this Contract Act, how horse racing, betting in respect to horse racing is made legal. So because it is an England law, in England horse racing was their main sport, and many things relating to that, whatever that may be. Okay, such kind of practices was even in Contract Act itself. So one betting was, they authorized horse racing and related betting. And now in different states there are different kinds of betting, lotteries or casinos or something like that. So it is done through different legislations. So keep that in mind. So for your examination you should understand what these wagerings are void. Okay, wagering contract, you cannot bet. Okay, betting cannot be enforced through court. Okay, only horse racing related questions will not ask from that area, but there is express provision in Contract Act which says betting related to horse racing is fine. Okay, that's weird, but what to do? So that is the things relating to void agreements. Keep these things in mind, keep a note of it. I'll provide you this note in our WhatsApp channel. The link to our WhatsApp channel is provided in the description. Join our WhatsApp channel, where we will give you access to our website soon. In 1 month you will have access to mocks and our website, which will be very useful for you. It is free of cost. You don't have to pay a single rupee. Everything is completely free of cost in our coaching program. So look through this, understand this. If you have any doubt about this area, void agreements or voidable agreements, please comment on your comment section and I'll get back to you. Okay, I will comment as soon as possible, reply as soon as possible. I am thinking I am doing fine. I don't know if I'm doing fine or not. I don't know if my language and my method of teaching is fine or not. So your comments is the one thing that will keep me going. Now this is a previous year question. Okay, this is a question exactly from 2025 December CLAT examination. So now read this question and try answering this question. If you look at the hand, I have to tell you one more thing. I have read this question. There was mistake in this question. Okay, and maybe I don't know if it was wrong. There was something wrong with my answer key. But when I checked through the answer key and the question, I found some two of the options wrong. Two of the questions and their answer given in the answer key is wrong. Okay, but just check it out. Read the question. Okay, read the question, try to answer the question. We know everything that is mentioned in this passage. So I believe you have read this passage. If you haven't read this passage, please go back 10 seconds back and pause it, read it well, because I'm not going to explain everything in this passage one more time. So because you have to develop eventually, right? Eventually you have to do better and better and better. So this is the process. Now I will not explain everything in this passage. I will just tell you the central idea in this passage. Okay, this passage has some things that I have not expressly stated while taking my classes. So let's just look into the central ideas in these two paragraph. The main idea of the passage is it deals with void and voidable contract. It sums up the entire concept of void and voidability. And here it says that in the cases of void contracts, what is the scenario here? They cannot enforce, even if both the parties are interested, they cannot enforce it. Now, what is the condition in relating to the voidable contract is that agreement was initially enforceable but later denied at the option of either of the party due to various reasons. That is the main theme there. In the second paragraph, when you get to the second paragraph, the idea changes. Here a new idea, like these things are already implied, but it is not expressly stated by me in my classes. So think about it. The idea is that in voidable contracts, the main thing is it is subjected to compensation. Okay. In cases of void agreement, neither the party is subjected to any compensation of any losses, but in voidable contracts, they have some remedies. In voidable contract, I have been coerced into entering into a contract. They have fraud me, they committed fraud against me. That's why I entered into a contract. Now I will get a remedy. But in void contracts, there is no remedy. Okay, you entered into a contract for a drug deal. So he took 50 lakhs from me and he told me that he will send me cocaine, and he didn't deliver me cocaine. So can I take this case to a court? No, it is not possible. It is a void agreement. Okay, in voidability, there is a possibility of remedy, but in void agreements, there is no possibility for a remedy. That is the one different idea from the class that has been mentioned here. But this is a previous year question paper, but no questions has explored this idea right here. Okay, this is a fresh idea, but this idea was not explored in your questions. Okay, it's in this passage they have given this idea, but these ideas have not been explored in the question paper. Questions are very simple. You could have attended the answers without even reading this passage. Okay, that is the skill we are acquiring now. Okay, by attending my contract classes, what the benefit is that while writing your examination, sometimes you don't even have to read the passage. You can get the answers without reading the passages, but it's good to skim. Okay, always it's good to skim. First question, try to answer this question. Which one of the following best describes a void agreement? This was your previous year question, last year question. Okay, which of the following best describes a void agreement? Try answer this question. Okay, an agreement that is valid until declared invalid by a court, an agreement which has no legal effect from the beginning, an agreement that is legally enforceable, an agreement that can be enforced if one party choose to do so. Okay, this is not it, right? And this is not it, right? This is not it, right? So answer is C, an agreement that has no legal effect from the very beginning. Okay, that is the void agreements. Now moving forward. Okay, B, sorry. A contract between two parties to rob a bank and share the proceeding equally can be termed as. What can it be? Is it a void contract, valid contract, voidable contract, legally enforceable contract? What will be your answer? This was your previous year question. It was so simple, right? Now, when you look at it, it's so simple. But if you don't know contract, if you haven't read about contract, if you never had a class about contract, this might not be as easy as it looks now. So the answer is very simple, A, void contract. Now, okay, you should comment your answers on the comment section. Okay, you should comment your answers on the comment section. That shows your enthusiasm. That gives me energy to do more classes. Okay, otherwise I will not feel the same energy and I may not end up taking more and more classes. Okay, if you want to have more and more classes, if you like to have more and more classes, please do respond, please do like, please do comment. Okay, now third question, an agreement made by an adult but involving a minor child where the signatory is a minor child himself, this agreement would be. This was a question. Okay, and the answer key which I had in my hand was wrong. Okay, I don't know if that was CLAT answer key proper, if there was an error to that or not, but that answer key was wrong. Think about it. Have I mentioned that, like, capacity to contract? We have discussed about capacity to contract in our previous class. We will deal with the capacity of contract again. Also, I will briefly we will discuss about capacity to contract. But this capacity of contract. We have discussed in our previous class. We have done an exercise based on that. Even in that, we have clearly mentioned that. Okay. 17-year-old child cannot enter into a contract. We have done a question based on that. Okay, what is the capacity to contract? A person should be a major to enter upon a contract. He should be above 18 years of old. So a contract with a minor is ab initio void. Okay, that is the capacity that comes under the capacity of contract. We have not discussed that in today's heading, void contracts heading. I haven't provided that under there. I haven't provided mistake under there. So these comes under different headings. Okay, capacity to contract. So a minor does not have a capacity to enter upon a contract. So a contract with a minor child is what? Void. So answer is, it is a void agreement. It is a void agreement. In the answer key, it was provided voidable agreement, which is wrong. A contract with minor is, you can check yourself. You can check at the Contract Act, you can check at Google, you can check anywhere else. You can ask other faculties from other universities or other places. You can ask anyone, a contract with a minor is dash. Or you can check previous year question paper discussions. Okay, I haven't looked at it. I'm sure any lecture would say what a contract with a minor is void. Because that's as simple as that. And there are some circumstances in which we can enter into a contract with minor and unsound person, that we will learn separately. Okay, we are in a process of learning. Okay, we will get there soon. Initially, what a contract with a minor is ab initio void, and this was an example of void contract itself. Okay. Which of the following scenarios would most likely result in an void agreement? Answer this question. An agreement signed by someone under duress. Okay, duress means coercion. Okay, duress is another word for coercion. Okay, remember that. Okay, a contract with mutually agreed terms to sell a house. An agreement to pay 10 lakh on getting first class in college. A contract with a minor who understands the terms. Very easy. Right? Okay. You might get confused with C and D. Right? Okay. There is a very good possibility you get confused with the C and D. The thing is that I don't think it was first class. It was something else in the original question paper. 10 lakh on something else. It was something else. Okay. There are two, you might think this as a wagering contract. You will think that it is a wagering contract. No, there is another kind of contract called contingent contract. Okay, we will discuss about wagering and contingent contract also separately. We need to discuss those portions. There you will understand that this is a contingent contract. This is not wagering. Okay, for example, it's not easy. You need to get to contingent contract. But this one, okay, you don't need to know what is a contingent contract. Like void contract, we are discussing about void contract, and this is very expressly non-fact. A contract with a minor, even if we understand terms, it is void, because the law is simple. The contract with a minor, agreement with a minor is void. Okay, so by that itself, it's a simple answer, and later you will understand about contingent contract and wagering contracts, and you will understand why this is not the answer here. So moving on. Sorry, answer is already there. An agreement without consideration is generally what happens with the, we have discussed this previously. I have this while discussing about void agreements. I have pretty much deeply and very well I have explained what happens when there is a contract or agreement without consideration. It will result in an void agreement. We already know the answer to it. So these are the things that you have to look for. Answer is already given there, so I don't have to discuss it, and you already know the answer to this question because you have attended my session. Now we will be dealing with consideration. Okay, from the first session itself you know what is consideration. We have discussed about everything that in 2 clause A to I we have discussed it. 2 clause D, what is consideration, I have explained to you what is a consideration. What is a consideration? Those who have not watched the previous classes, please click on the I button and get back to the first contract, law of contract part 1 session. Please go back there. Okay, or go back to our playlist in our YouTube channel. Go to law of contract class 1. There we have defined every important terms in contract. Okay, for a clear idea, I will mention what is consideration here. Consideration is simply what we are something that is of value in the eyes of law, that has been transferred under a contract. I'm giving money for a bike. Bike is my consideration, money is his consideration. Okay, something of value in the eyes of law, that is called a consideration. That's okay. An agreement without a consideration is void. We have already discussed that agreement without consideration will become void. It will not contribute, it will not ultimately become a contract. A contract or agreement itself is void. Consideration is something of value or worth in the eyes of law. Consideration is something of value or worth in the eyes of law. The contract act defines consideration to be some act, abstinence or promise from the part of the promisee, okay, or acceptor at the desire of the offerer or the promiser. Simply means, okay, whatever we are doing, okay, it may be providing something, it may be doing something for some person, or sometimes it may be giving up something we already have, or some anything that is done by a promisee, okay, done by a promisee for the offerer. You don't have to remember this complicated idea. Okay, the idea is very simple. We are giving money for bike, and this money for bike is called consideration. Okay, all you have to know for your purpose is simply that. Or you can avoid all other complexities and complex explanations. Okay, simply what you are giving, what is the valuable you have transferred to each other. And we have previously discussed when this valuable, when this consideration become illegal, the contract will also be a void agreement. It will not ultimately result into one contract. We have already discussed these concepts, right? Consideration can be legal, illegal, or of an illegal object, anything. Okay, an agreement can exist. It doesn't matter if it is legal or illegal. Okay, a contract will only come into force if the agreement is enforceable under court of law. Okay, we have discussed these principles previously, so let's not waste our time. We will learn some Latin maxims. Ex nudo pacto non oritur actio. No action arises from an nude agreement. When the agreement is void, when there is no consideration in an agreement. If an agreement does not have consideration in it, okay, that kind of agreement is called a nude agreement. We have also discussed this in the first class. Okay, if I am telling someone that I'll give my bike for free, I'll give you my bike for free. Today I told someone I will come tomorrow to my home, I will give you my bike for free, and he arrives at my home tomorrow morning 7 p.m. or something, and he 7 a.m. and he asked me for my bike, and I said no, I'm not interested in giving it to you. Okay, he cannot make any claim upon it because there is no consideration, there is no agreed amount upon it. I was interested in giving it to him gratuitously. Okay, these are the things. Okay, a contract will become only enforceable when there is a consideration inside it. Okay, no action arises from a nude agreement. In other words, no action arises from an agreement without consideration. Nudum pactum, an agreement without consideration. Okay, nudum pactum. Nudum pactum. A nude pact means an pact, an agreement without consideration. That's how simple it is, right? It's very simple. This is very easy to understand concept. So next, what we are going to do is we are going to learn about certain circumstances in which a agreement will result in contract even though there is no valid consideration. Okay, circumstances under which when there are no valid consideration, still it would amount to contract. Okay, in certain circumstances, those circumstances are what we are going to learn next. See, what we are dealing with here is there are few exceptions where agreement result in a contract without any consideration. Okay, those circumstances are what we are about to learn now, and we will do some questions based on this also. Okay, sometimes in your question paper they will provide this information as your principle or as a paragraph, then they will provide some questions relating to it. You will have to solve. That is what we will be doing today in our live session. So these are conditions when a agreement constitutes, agreement result in contract even when there is no consideration. So while reading this about these notes or while going through this material, you might seem like these are valid consideration, these are things of value. You might think so, but the problem is, okay, we might feel so. We are human beings. We might feel as these things are valuable. Okay, but law does not feel things. Okay, so law, in the eyes of law, what we are about to look, most of the things and circumstances that we are about to look, it does not consider these things as consideration. We might think so, but law doesn't presume so. Okay. So these are the exceptions. We are going to look into the exceptions of the requirement of consideration for a contract. So first one, natural love and affection. Okay. So if a person writes and registers an agreement, writes and registers, and so read that. Okay. In your question paper, it will, if it is clearly mentioned, look for it. This is a very important thing to look for. Okay, in your examination, you don't have to use your own ideas for writing answers. Okay, in your for your exams, you have to apply only what that has been provided in the passage. I am helping you understand these things better by taking these lectures. Okay, so don't try to use information that you already know. That is why I have clearly mentioned in my previous classes itself that you have to skim through the material. Okay, skipping is the last option. Skipping is the last option. If you don't have enough time, you can skip the passages. In all other circumstances, it's better you always skim through the material to understand what it is mentioned there. Okay, you have to only use the materials that has been provided in the passage, whatever it may be. So here what it is mentioned is that by natural love and affection, if someone writes and registers an agreement, then that is a valid agreement, that is a contract. It results into a contract. So I have written a document that says I'm selling or I am giving my properties to my son out of my natural love and affection. This is a valid contract. Okay, no one can say that this is a void contract because it doesn't have any consideration. He is selling it for what now? Love and affection. What is love and affection? It's not valuable thing that is of value in the eyes of law. Yes, it is not a thing of value in the eyes of law. It is only a valuable in the eyes of human beings. But what is the thing? The thing is, it is a exception to the rule of requirement of consideration. So understand that natural love and affection is an exception to the rule of requirement of consideration. Second one, past voluntary services. What is a past voluntary services? We are doing something for someone voluntarily without the need for any money. Okay, we ourselves did it. He didn't ask us to do it. We ourselves did it out of our gratuitous, out of free will and free interest, and as a for a because we of our good nature. Voluntarily we did it for someone. And that person, if he says that okay, he will pay for it, okay, we didn't do it because he asked it, okay, he didn't mention he will give money for anyone who does it. No, we did it voluntarily without anyone asking us to do that task, and we did that, and we didn't expect anything from him. And then he says, okay, since you did it, since you voluntarily did it, I'm going to pay you. If someone says that, then the problem is it will result into a contract. Okay, but now you might be thinking, oh, here is a consideration. He has done something for the other person. No, it is a past voluntary services. There was no offer. Okay, contract begins with an offer. Here, there is no offer. He didn't ask me to do it. I did it voluntarily. So it has been done in the past. The voluntary work was done in the past. Then he agreed to give me money. So past voluntary services. Now he is giving me money for nothing. I'm not giving him anything for that money. Okay, I have done it previously, but you can't bring something into contract that I have done previously. Okay, so in the eyes of law, what is happening is he is giving me money. I am doing nothing in return. Okay, but this is a valid contract because we have done a past voluntary services. Okay, so contract made upon a past voluntary service is valid even though it lacks legal consideration. That is what mentioned here. Okay, past voluntary service. A finds B's lost purse and give it to him. B promises to give rupees 50. Is a contract. Here B is paying to A for something he has already done for which he didn't expect any remuneration. Once he promised to pay, he cannot go back on his words. Okay, so that person was not expecting to be paid. He was not expecting any remuneration. But if you offer him to give him that money, some remuneration, then you will have to give it because that will end up into a contract. That will result into a contract. Now, next one is time barred debt. Okay, written and signed by debtor or his agent. Okay, a consideration. This is the situation in which the consideration in a contract is a time barred debt. So what is time barred debt? The question or passage will not mention what is a time barred debt. These are the things that you have to know. The time barred debt is any debt, okay, its period of recovery is over. Okay, you may not understand that properly. In India, we have an act called a Limitation Act. Okay, this Limitation Act provides for the time period under which, okay, we can file any case. Okay, not just the recovery, any case. It provides the time bar within this many years, within this many months, between these many days. We have to file a case to get a remedy. That is the purpose of Limitation Act. It limits the time period under which we have to claim compensation or remedy. So sometimes the statutory period for making that claim may be over. Okay, someone has lent me some money. Okay, he hasn't asked for the repayment for about 16 years. Now he cannot come from a random day morning. He cannot come and claim that money from me. Why? Because the statutory limitation period was over. He cannot claim that from me. So what law says here is that he has a right. Okay, I know, I understand there is an agreement between you, or I have given him a check or something, whatever it may be, but you have a right to claim that money, but I will not enforce it. Court will say that. The court will say, I recognize there is a right, but I will not enforce it because the limitation period is over. You have to claim before this speculated period. Okay, it's there with the check. Negotiable instrument cases, there is a limitation period. You have to claim that money within that period. If a check bounces, it gives you a time bar. You have to claim. You have to make a claim within that period of time. If you have failed to make a claim within the period of time, then that case will not stand in the court. Okay, there are other ways to deal that case, but in a straight manner, in a proper litigating manner, it is not possible. So what law says about time bar debt is, it is a debt that was recoverable, but you didn't try to recover it within the time period. So now you do not have the right to claim it. Okay, law will not enforce your right. That is why time bar debt or called imperfect right. You don't have to learn about that. Time bar debt is also an example of imperfect right. The court or law will recognize it but will not enforce it. Okay, that's a funny thing about it. So a time bar, so there is a time bar debt. Okay, I owe money to someone, but the time bar has passed. So he cannot officially, legally, he cannot claim that money from me. But if if we are in writing making a new agreement, which says, okay, I'll pay back him this money. Now this debt will become recoverable. But the thing you should understand, in the eyes of law, this old debt, it's not recoverable. It has been forfeited. So for law, this situation is like there exists nothing. I don't have to pay him anything. So now when we are making a promise to pay a time barred debt, what law is saying is, this is an contract without consideration. Even though this is a contract without consideration, I am accepting it as a valid contract because I will consider this as an exception. I will consider this as an exception to the rule of requirement of consideration. For human beings, for us to understand, it's very simple. It is the money that he owes to him, so he have to pay it. Okay, for law, for the eyes of law, law cannot see that depth. Okay, law cannot see that depth. Law cannot see past voluntary services as a valuable. Law cannot see natural love and affection as a valuable. That is a problem with law. It's not the problem with us. So these are the presumptions of law. It is not an issue with human beings. It is an issue with law. So that's it. Time bar debt, written and signed by debtor or his agent. Time bar debt is money that you borrowed and didn't repay, but which is no longer legally collectible because a certain number of years have passed. But if he again makes a promise in writing, he will be liable to pay it. Simple as that. Okay, I might have made it complicated by explaining it, but while reading this material, it might have become clear for you. So without overcomplicating and over-explaining things, let's try a passage and try to answer some questions. So this passage reflects what we have learned from our previous slide. So just try to read it and then we will answer these questions relating to the passage soon. So please pause this screen and read it yourself. So I hope you have read what is written in this passage. And if you haven't read, please go back 10 seconds back and pause the screen and read it. Okay, I will not be explaining this passage in detail because it reflects what we have learned from our previous slide. But there is a small problem with it. The issue is the third point. The third point is same that of the second point, right? It talks about the voluntarily doing something, past voluntary service. Okay, 2 and 3 are same. So let's forget what it says in third point. Instead of third one, I am telling you that third point. Thus, this third point is time barred debt. Okay, we have previously learned time barred debt is an exception to the rule of what? Consideration. Okay, even a contract with time barred debt is a contract. It will an agreement with a time barred debt is a valid agreement and it will become a contract. Okay, we have previously learned that. So that is the third point. Let's consider that as our third point and let's move to questions. Our first question. Okay, our first question is here. Which of the following best describes the meaning of consideration? Okay, which option describes what meaning of consideration? love and affection between family members, mutual agreement between two parties, something of value exchanged at the desire of the promisers, a document signed before a notary. Tell me, what is consideration? It is what? See, something of value exchanged at the desire of the promiser. Okay, on our first slide itself, we have discussed what is considered. It is something of value. Okay, and the second part, it is decided at the, it is exchanged at the desire of the promiser. We have discussed who is promiser, who is promisee, who is offerer, who is offering in our first session. Go back there and remember it. Okay, so next slide. A father orally promises to give his son 1 lakh out of love. He later refuses to pay. Can the son enforce the promise? Okay, I want you to answer this question yourself. Okay, it will be better if you put your answer in the comment box. Okay, or else you can write it down on your paper or something. But it's better if you put your answers on the comment box, because it will give us engagements. Okay, it will be an encouragement for us to continue these classes. Okay, yes, because there is love and affection. No, because there is it is not in writing and registered. Yes, because it is a family promise. No, because love is not enforceable. What is the answer? Don't rush to the answer. Most of you might rush and you will write yes because there is love and affection. Some of you might write that as your answer. But the problem with that is, in the passage and in my slide, even in my slide, I have clearly mentioned there, it is clearly mentioned what it should be registered and in writing. Okay, it clearly mentions that it should be registered and it should be in writing. Okay, an agreement is made out of natural love and affection and is in writing and registered, it is valid. So the passage tells you that it should be like that. Then it should be like that. Okay, so don't assume something yourself. Okay, you have to apply what is there in the passage. So the passage itself tells you that it has to be in writing and it should be registered, then it should be done so. If in the passage there is no, it does not mention, it should be in writing and it should be registered. If it's not mentioned in the passage, then you can say option A is the right answer. It is because there is love and affection. Okay, but the problem here is the passage clearly mentions that it should be in writing. Okay, and it should be registered, then it should be done so. So the reading passage is very important while writing your answers. So the correct answer is B. B is the right answer. Next question. Ravi helps his neighbor Sadish recover from an accident by taking care of him for 2 weeks without expecting payment. Later, Sadish promises in writing to pay 5,000 to Ravi. Is this agreement enforceable? Please write your answers. There are 4 options. A, no, because Ravi helped voluntarily. Yes, because this falls under the past voluntary service. No, because consideration is absent. Yes, because it is a time-barred debt. So write your answers. So what is the right answer here? Yes, because this falls under the past voluntary service. So B is the right answer. He has previously done an act, he has done it voluntarily, but then that person promises that he will pay for it, then it is enforceable. That's a very plain, easy understanding. Which of the following is a nudum pactum? Which among the following is a nudum pactum? The question is, which of the following is a nudum pactum? 4 options are there. A written promise to pay a time-barred debt. A verbal promise to donate 10,000 to a friend without consideration. A gifted from father to a son registered. A service contract where payment is mentioned. Which among this is a nutum pactum? An agreement without consideration. Or simply, which one of this is a void agreement, or which one of this is a void contract? So that is a question. Answer is B. Okay, a verbal promise to donate 10,000 to a friend without consideration. We are telling your friend, I will give you some money, and next time we are not providing him any money, so he can't sue us because we were in making an agreement. He is not giving something for me for that price. I am not buying anything from him. So we have already discussed that. This is a perfect example of agreement without consideration. What is on the other hand, a written promise to pay a time bar debt? This is not a nutum pactum because the law of contract accepts time bar debt as an exception to the rule of requirement of consideration. So this will not become a nude agreement. Father to a son, we are accepting it. A service contract where payment is mentioned, we are accepting it. This is a proper contract. Service contract where payment is mentioned. So these are valid situations. Only of situation where it is not there exists no consideration. There is no valid consideration, or which a situation in which it will not amount to a valid contract or agreement. Well, agreement becomes void is the situation of B. Okay. With this, I will be winding up my second session. I know to the end of our second session, my energy was a bit low. Sorry for that. I have been taking continuous classes, but I believe I have explained things as effectively as I can. If you have any opinion regarding how my classes should be or how should I improve my classes, please do comment on the comment box. I will make such improvements and I'll get back to you on the third session. Thank you very much. And for getting notes and other updates, please join the WhatsApp channel using the link provided in the description. Thank you all.